Madam Chair and members of the committee, Ben Lopez with Traditional Values Coalition. Welcome to the Senate. Senator Torres, my own senator, by the way. We're obviously opposed to the bill, and this bill is based on an open-ended definition of gender identity and expression that we feel has no bounds and limits. AB 1266 is basically based on Penal Code Section 422.56, and it states, gender means sex and includes a person's gender identity and gender expression. Gender expression means a person's gender-related appearance and behavior, whether or not stereotypically associated with the person's assigned sex at birth. This bill would call for any student and young adult who perceives themselves to be something other than their sex at birth to share shower facilities, restrooms, locker rooms with the gender or sex they feel they are at any given time. The problem is that this bill, nor current law for that matter, affords a clear definition as to what constitutes legitimate gender identity and gender expression. The bill opens up Pandora's box, in effect, that creates a slippery slope by allowing anyone to claim they are something sexually and then have full access to the opposite sex facilities without regard to privacy. We feel this is an absurd and offensive policy that would not bode well with the majority of students. CIF has actually greater teeth and requirements in their requirements than this bill or current law has with respect to documenting what is perceived legitimate gender identity. The law doesn't even go that far. It's open-ended. The CIF regulations require specific items and standards to be met. Out of a category, they have to list or meet 3 standards in order to be classified as legitimate having a gender identity issue or expression issue on hand. There is consensus among those of us in opposition, and my colleague to my right. Basically, we would state that this bill has a complete disregard for the privacy of the vast majority of students who are not transgender or gender questioning. These students and their parents have reasonable expectations that they will not be forced to share intimate spaces with members of the opposite biological and anatomical gender. There are no safeguards whatsoever in the legislation that would allow reasonable adults, coaches, teachers, chaperones, what have you, to act in a way that is in the best interest of all students. Furthermore, because there is no delineated, this is an open-ended definition and there's no delineated standards, financially strapped school districts are likely to be sued for actions they either do take to try to remedy this problem or fail to take in trying to remedy this problem. There's several court cases from even the Ninth Circuit Court of Appeals that stated with respect to fair housing and an issue involving roommates that basically the privacy concerns of an individual must prevail over anti-discrimination laws. There's a level of reasonable privacy that must be maintained, courts have ruled, both privately and publicly. And those are irrespective of anti-discrimination laws in several of the states. I guess if this bill were to pass and be signed into law, California would have probably a lawsuit on its hand with respect to this bill, and I would assume that precedent in other states in the Ninth Circuit would hold true. For these issues and a variety of other issues, Madam Chair and members of the committee, we implore you to vote no on the bill. Give this some pause and consideration. You don't need to pile on another law to get about forced compliance. There's plenty of mechanisms in place that could help with compliance. You don't need another law simply because you want to appease your constituency base. We ask for your no vote.